everyone. Welcome to the Introduction to Mock Trial video series. In this video, we are going to be covering what is a mock trial. So before we get started, I just want to take a minute to position this video in our introduction series. This video is intended to follow the video on what is a trial. So if you have not already done so, I do recommend that you take a moment and watch the video on what is a trial, because that will give you some context and really set the stage for what I'm going to talk about in this video segment. So let's get started. A mock trial is very much what it sounds like, in that it is a simulated trial. So for OCLRE, we offer both a middle school and a high school mock trial program to students throughout the state of Ohio. And as we said, it's simulated, so students are going to actually be playing the roles of people who would be involved in a real life trial. So students are taking on the roles of attorneys and witnesses. And OCLRE has sort of free reign over how we choose to format our trials. So that could mean one year it is a civil trial, or another year it's a criminal trial. And that there's no set pattern on how that goes from year to year. Just know that you could potentially have a civil case such as a libel case, or you could have a criminal case where it could be something like related to a murder. It's rarely a murder itself because of the constitutional issue, which I will get to next. But if we could have it where it's a murder trial every year, we know our students would love that. But criminal trials often take on the form of something like a petition to exclude evidence based on a violation of somebody's Fourth Amendment rights. So things like that, and I'll go into a little more detail throughout this introductory series, but just know that OCLRE cases can be either civil or criminal trials. And this next bullet point is actually specific to high school mock trial, but all of our high school mock trial cases are based on constitutional issues. So that's what I sort of just mentioned with the Fourth Amendment or libel cases. So I use those examples because we have cases that have been based on those in the past, because we believe that as part of this educational program of offering a mock trial, we really want to make sure that students see the connection to our criminal justice system and to the government. So that's why we have this rule where cases are based on a constitutional issue. And that can be anything. It often comes from the Bill of Rights, so something like a First Amendment case where it's freedom of religion or speech or press or something like that, like in a libel case. Or it could be a Fourth Amendment case on searches and seizures. So it can be any number of items that are in the Constitution, but we do make sure that our cases revolve around that so that you can have really enriching discussions with your students and you can make that curricular connection. So they're learning about the Constitution and then also Supreme Court cases that tie into that constitutional issue. So that's a really important part of the high school mock trial program. And on the flip side, the middle school mock trial program does not always focus on a constitutional issue. Rather, what we do for middle school mock trial is we make a pretty strong connection to literature, because all of our middle school mock trial cases are based on pieces of literature commonly used in middle school grades or commonly read in the middle school grades. So we have an existing repertoire of several cases that are free to be ordered and used at every time. And we always have one case that we use as our showcase piece. But just some examples of literary connections, we have cases for Roll of Thunder, Hear My Cry, The Giver, The Outsiders. We recently, as recent as last year, wrote a new case based on the book Holes. So you can see that these are books that you commonly read in middle school levels, and we use those to create a mock trial case, which just helps students connect what they're learning in English to their performance and their participation in the mock trial program. So what a team looks like for a mock trial, because I mentioned that there are roles of attorneys and witnesses, you have multiple students on a team. So for a high school team, you have a minimum of 5 students and a maximum of 11. And then that's just slightly bumped up for middle school, and that you have a minimum of 6 students and a maximum of 12. And we will, in another video in this Introduction to Mock Trial series, we will discuss the structure of a team and how to organize. But just to give you a heads up as to why those numbers are where they are, it's based on the roles that they have in the case. So high school mock trial, if you have 5 students, that means that all of your students are going to be doubling up on roles, where you can have 11, where each student only has 1 role. And then you also have some backups. So people that don't necessarily want to be actively involved, but they want to be ready as an alternate and things like that. So I don't want to get too carried away with that section, but just know that there is going to be another video talking about structure and organization. And that also leads into the reason that you can potentially have a double up on role is because every mock trial team will present both sides of the case. So if you see the pi symbol and the delta, those stand for plaintiff, prosecution, or defense. We have that little key at the bottom of the slide there, because teams will prepare their entire case. So they will present both the plaintiff or prosecution side, and then they will also, in a second trial, present the defense side. So know that they are preparing both of those. And then all of this really comes to a head. It culminates, that's the word I'm looking for. It culminates in either for high school, it's a statewide competition, or a showcase, which is for middle school. So just keep in mind that the high school program is a competition track, where middle school is a showcase. So there's no one declared winner, but they still get to present everything they know and do their trial in front of volunteers who evaluate their performance and give them feedback. So just to give you some measure of how large our programs are, we have approximately 190 participating high schools, and that can change from year to year, but that's our ballpark for high schools, and then 47 participating middle schools. And we've seen tremendous growth in the middle school program over the last couple of years. So we do have quite a few schools and teams and students that we work with throughout the state of Ohio. Okay. So as I mentioned, there are the numbers I gave you of minimum number of students and maximum number of students. These are the roles that those students will be filling. So roles on a team, this is for each side of the case. Keep that in mind. As I mentioned, you present the plaintiff, prosecution, and you present the defense. So there are roles in each of those. 2 attorneys on each side. So you will have 2 plaintiff prosecution attorneys, 2 defense attorneys. So that could be 2 students that do both, or you could have 4 students and have somebody only work as an attorney on the prosecution, somebody only work as an attorney on the defense. And then for high school, you have 2 witnesses on each side. So 2 plaintiff prosecution witnesses, 2 defense witnesses. That is different than our than our middle school program, because middle school, there are 3 witnesses on each side. And the reason for that is knowing the different level of ability between high school and middle school students. We do have an added strategy layer in our high school program, where our case file actually includes 3 witness statements for each side. And then it's up to the students and the team to really work together and figure out which of those 3 witnesses they choose not to call. So they're only going to call 2 out of those 3 for a high school team. And that is a really big strategy part of presenting the case, because you never know what the other side is going to call. So you have to be prepared. But you also want to prepare all 3 witnesses, but know in your trial strategy how you are going to choose only 2 of those 3. For middle school, knowing that the strategizing might not come at the same level as high school, we've removed that element, and we include 3 witnesses, and middle school presents all 3 witnesses. And then in addition to the attorney witness roles, there's a timekeeper / bailiff for both sides. It is required to have a bailiff for the prosecution side. So sometimes teams will make it be the timekeeper and the bailiff are the same student. They perform those same roles. Really what that means is bailiff is responsible for opening the court, introducing the judges, and closing the court, and swearing in witnesses. So there is some speaking role involved in being a bailiff. That same student can also be the timekeeper throughout the trial, or you can choose to have a separate timekeeper and separate bailiff. But then on the defense side, you have just one person being the timekeeper, because only prosecution is responsible for providing the bailiff. And that is mainly for middle school, where we see a timekeeper and a bailiff be two different students. For high school, it's the same person. And so as you go through this and you start to think about it, please feel free to reach out to me directly with any questions on how this works and what's permitted or what we should do under the mock trial rules. I'm here to help because I know structuring teams can be a little bit complicated. And we'll talk about organization more in a later video, so just keep that in mind. And as I've mentioned or alluded to previously, a student can serve a role on each side of the case, but they cannot have multiple roles on the same side. So you could have one student who wants to be an attorney for the plaintiff and an attorney for the defense. That is totally fine. But you cannot have that student be an attorney for the plaintiff and a witness for the plaintiff. So they have to choose just one role per side. And that we will get into a little bit more later. But a team of 5 students, as I mentioned before, in the high school, that's the minimum. That means every student is going to be doubling up. So they'll play a role on both sides of the case. If you have your maximum number of students, then that means you're going to have just one person playing on prosecution and somebody else playing on defense. So there wouldn't be doubled up roles. And you're free to do that however works best for you and your students. So there's no one right way, no wrong way. It really is what works best for the strengths of your teams, practice time, and all of that. Okay, so this also goes back to what is a trial, but this is specific to our mock trial setup. So this is the sequence of events on the day of your competition or your showcase. So it opens with the very first thing being a pre-trial conference, which is a time for the attorneys on the team and the team advisor to meet with the presiding judge. And at that time, it's not discussing anything that you're going to be doing during the trial. It's really to talk about any courtroom etiquette. So if you know as an attorney, you like to walk around the well of the courtroom as part of your delivering your open or asking questions, you just want to make sure with the presiding judge beforehand during this pretrial conference, you ask questions. Say, judge, is it okay if we move around the well of the courtroom? And that's up to the judge. It's their preference. Sometimes they might say, space is limited, so why don't you just stay standing at your table or at your podium just because it's limited space. Sometimes they might say you're free to move about the well of the courtroom. So things like that, it's important to discuss during a pretrial conference. And anything else, so if you have a student who maybe has an injury and isn't able to sit in the witness stand, you want to address that during the pretrial conference just so the judge knows ahead of time. So it's just little things about the actual things that will take place, but not the content of the trial. So that's your very first part of the trial sequence is your pretrial conference. That takes about 15 minutes, depending on how many things you have to get through. And then once the court is open and everybody has been seated in their correct places, the judge will instruct the attorneys to begin with opening statements. So the vast majority of the time, unless otherwise stated, the plaintiff or prosecution will present their opening statement first. And then after they've concluded, the defense attorney will give their opening statement. So for almost all of our trials, unless otherwise stated, the plaintiff prosecution is going to go first in every part of the trial. So they will give their opening statements first, they will examine witnesses first, and they will give their closing arguments first. So keep that in mind, and we won't change that without explicitly telling you in the case file. So once both sides have delivered their opening statements, they will go into the direct examination of the plaintiff or prosecution witnesses. So they have, for high school, 2 witnesses to get through. For middle school, they have 3. So the attorney on the plaintiff side will direct examine their own witnesses. And then once they're done direct examining that witness, it goes to the opposing counsel to cross-examine that witness. So that's the process for each of the witnesses. The attorney for that side does the direct examination. They conclude direct examination. Opposing counsel crosses. And then if needed, this is much more common in high school than it is for middle school, but it's permitted in both. You are allowed to redirect and recross-examine a witness. So an attorney if they want to help their witness recover, maybe they didn't have a great cross-examination or they gave up some materials that might not be great for their side, there is an opportunity for the attorney to redirect that witness to clarify anything. And then the same way, there's a point for opposing counsel to recross that witness if needed. And we will go into that much more in detail later, but just know that that is the process. So we get through all of one side, then we go to the next side witnesses. So defense witnesses go next. The same process repeats: direct exam, cross exam, redirect if needed, recross if needed. And then once all of the witnesses have been directed and cross-examined, we go into closing arguments. Again, the vast majority of the time, the plaintiff will go first, and then the defense will go second. And then once plaintiff has done theirs, once plaintiff has done their closing argument, defense has done their closing argument, the plaintiff then gets another opportunity to present a rebuttal argument just to clarify anything or really hammer home a point that needed clarifying after the opposing counsel's closing argument. So that is the actual trial in which the students are presenting. Once closing arguments and rebuttal have concluded, the judges will go back to their scoring room and tally up all of their scores, and then they come back into the courtroom and they present the outstanding attorney and outstanding witness awards. So in every trial, one student is given the award for being the outstanding attorney based on which attorney has earned the most points on all of the judges' ballots. So they combine all of their points and see which attorney scored the highest. That attorney gets an outstanding award. And they do the same thing for witnesses across both teams. All judge score sheets tally how much they gave to each witness, and then the one witness with the highest score wins the outstanding witness award. So each trial, there's one outstanding attorney and one outstanding witness, and that happens once judges have deliberated. They present the awards, give a brief commentary, and then that trial concludes. And going back to what I said earlier in the video, there is going to be two trials. So if your team presents plaintiff in trial 1, they will present defense in trial 2. So they'll do the whole thing, just doing the other side of the case. And we will tell you either the day of or 2 days before which side your students will be responsible for presenting first. But stay tuned for more of that information, and always check the case file, because that is where most of the information in terms of how this trial sequence is going to go, you can find that information in your case file. And as always, please feel free to ask me any questions. I'm always available via email, and you can give me a call if you want to just talk through some things, because it can be a little bit complicated. But I believe that concludes our presentation for now, and we hope that you'll continue to tune into our Introduction to Mock Trial videos. And if you have any questions at all, please do not hesitate to reach out.